Good morning, students. Today we will discuss general exceptions related to the private defense. Section 96 to 106 IPC is related to the private defense. So, students, we will discuss our live lectures on Jurist underscore Academy regarding the IPCs, and then important lectures we will upload on our YouTube channel, Jurist Academy. Since the IPC is one of the most important subject, for example, in MP Judicial Service, which most probably the first exam will become in northern area for the Judicial Service exam. I'm telling you the importance of a IPC in that exam. In preliminary examinations, it's a 150 marks paper, out of which 120 marks is related with the law and 30 marks are related with the GS part. So out of 120 marks in previous year, 20 marks, 20 questions were related to the IPC. So 1/6 of the law part is covered by the IPC. So that's why we will discuss detail regarding this IPC. So the students who has not subscribed our channel Jurist Academy, subscribe them. So because we will continue our IPC lectures on YouTube. So students, जो प्राइवेट डिफेंस है, जो सेल्फ डिफेंस है, it is the one of the most important right given by any state, any law to the human beings. If this right was not available to the human being, there will be total chaos in the civilizations, in the society. It has a deterrent effect because it has immediate remedy given to a human being. And based on the old principle, might is right. When we discuss this defense in the earlier times, in Roman law principle, that is principle of dominion. In this principle, who was the head of the family, that is known as Pater's family in Romans. So he has a right to defend his family and his property. And then the well-known phrase, that is principle of vim vi replere licet, which means every person is permitted to repel that force. So जो हर आदमी के पास repel करना जो है, it is mandatory. And Hobbes used first time this, this principle in England. So, because repel by force, which is the meaning of that phrase, and the Hobbes who used this English term first time, that is known as self-defense. In English law, this word is used as a self-defense, that which we used a private defense in our law. So, as the Hobbes argue that although some may be a stronger or more intelligent than other in nature, state known as so strong to be beyond a fear of a violent death, which justifies self-defense as the highest necessity. क्योंकि जो एक डेटरेंट इफेक्ट है भी, अगर आई विल अटैक तो आई विल बी रिपल, उसमें a person can even kill me, so that justify the this part. That's why Article 12 of Universal Declaration of a Human Rights mentions specially regarding this right of a self-defense or a private defense. And it is stated that no one shall be subject to arbitrary with the privacy, family, home, or correspondence, nor to attack upon his honor and reputation. Every has the right to be protection of the law against such inference or attack. So this right of protections is given to a person is justified by our Article 12 of Universal Human Rights Declarations. So which the Hobbes use the word this self-defense even given by this. So that's why drafter, framer of our Indian Penal Code had included the right of self-defense in section 96 to 106. Because it is a moral right also. Because Greek-Roman natural rights theory, in which Aristotle and other has also encouraged this right, because it is a moral duty of a person to defend their family, even a neighbor. And so right of armed self-defense even extended to the collective, to the community, to curb or prevent the persons from unlawful acts. So that's why English philosopher John Locke stated that natural rights were self-evident and gave a man to the power to pursue his life, his health, his liberty, and possessions. So the importance of this right, we consider that the person who follow the ahimsa, means Jainism and Buddhism, the monks who follow the rule of a ahimsa, not to fight any others. Even they were trained for the self-defense. If we know the games like karate, like kung fu, they were given by those monks. Because This right was even used by the saints for their self-defense. So when we consider this part, especially when we consider, especially with because the state, the state has no, especially the state has a wide duty in every field. They cannot, the state cannot interfere, and it is the normally a duty of a individual to protect him. And individual has a right when any this type of a dangers, because the purpose of the state is not to and discourage cowardness, and state is not always give a personal guard to every person. And so that's why a self-preservation is a necessity in the case of a nature. Or similarly, it is also the force used by that person should also be justified. And this is a justifiable defense is given to a person. So in general exceptions, there are two type of exceptions. One are excusable defense. They are given to is regarding those person who has a sanity, who has unsound mind, and the person who has, you can say, intoxicated. If a person has committed a crime under those circumstances, he committed a crime. His crime is excusable, but here a justifiable. Or the Bentham has given mention that this self-defense should be encouraged, and especially because it give a right to a person to defend his property, and that's why it is a duty of a man to help himself. And if we will not encourage this, then there will be a social disorder. Or similarly, that's why the Bentham in his book, The Principle of the Penal Code, has stated that fear of the law can never restrain bad man. मीन जो क्रिमिनल्स होते हैं उनको जो लॉ है वो डरा नहीं सकता, but as a fear of the sum total of individual resistance. And so जो individual resistance है उस बैडमैन को पता है, if I have taken any actions, a individual resistance will become, so it will even up to go to the death. That's why that bad man will be feared. So, so that's why Bentham said the right of defense is absolute necessary. So that's why on the 3 points, number one, the prime duty of the man to help himself. And second, self-preservation is the prime instinct. And third one is the right of a private defense is serves a social purpose. So that's why this right is important as compared to the other rights. Because we are not expect a citizens to run away. And that's why the Russells stated justifying this right has stated that this self-defense is justify a resisting by force. Anyone who manifestly intends and endeavors by violence or surprise to commit a non-crime against either his person, habitations, or his property. So that's why there is there is a nothing more degrading to the human spirit than run away at the time to face of peril. So ये कभी स्टेट इनकरेज नहीं करता कि आप जब प्रॉब्लम्स आए, ठीक है, आप उस समय भाग जाओ. So that's why, considering this, the self-defense depends, considering these propositions, that the society undertakes and in the great of majority of the cases is able to protect a private persons against unlawful attacks upon the persons and property. Second, that where it is aid can be obtained, it must be restored. That where its aid cannot be obtained, then individuals do everything which is necessary. So these are the principle on which private defense is based. And what जो violence है, what the जो retaliations है by the person in his self-defense, that must be proportioned to the injury to be avoided. So, in considering in the civilized society, these are the principles on which the right of private defense is mentioned. So, as per section 96, it is clear that nothing is an offense which is done by a person as a right of his private defense. So वो कोई offense नहीं है if it done by a human being, done by a person for the right of his a private defense. So this is known as inherent right, which protect a human being when the life, property of his friends or his relative is in jeopardy. It is the rest in a general principle that where is crime is endeavored to committed by force, it is lawful to repel that force in self-defense. So this was the idea, this was the concept behind the self-defense. Because beta, when you answer the question, you have to write the introductions part, which is necessary. You can only develop the introductions part because it is the most important subject and this is the most important defense. So normally a prelim and main, the questions always come on this. So now this defense, which included in India, you know that word self-defense is used in England. But in India, the word is used private defense. Why? Because this right given in India in wider sense than in England. In England, the self-defense only related to a person himself or his family, property, or a person who he has some relations like family relations, neighbor, friends. But in India, this right is given to a person, even related to a person who even is not known to him. So that's why this defense is available more wider sense than in England. So that's why thereafter, when the law codified, so section 96 to 106 of Indian Penal Code, this self-defense has been given regarding for the self-preservation is a basic human instinct. And so in chapter 4, in general exceptions, this self-defense right is given. And section 96, which declare nothing is an offense which is done on the exercise of the right of a private defense. So section 96 is mentioned that it is clear by wording nothing is an offense which done in exercise of the right of a private defense. So section 97, which deals with the subject matter of the right of a private defense in a body and the property. And it lay down that it extends the right of a private defense, proclaims that every person subject to restrictions contained, that is contained whatever the restrictions in section 99. So section 99 has a right to defend his own body and body of another persons against any offense affecting human body, and the right to defend of any person. And similarly, section 99 mentioned a list of situations where the defense of body as well as property is not available to individual. It lay down the limits of the right. So in section 99, some curtails up to the limit of this self-defense right. So section 102 to section 102 and section 105 deal with the commencement and continuation. कब आपका जो राइट है प्राइवेट डिफेंस स्टार्ट हो जाता है और कब वो खत्म हो जाता है related to the body and your property. So section 100 and 101 and 103 and 104 deal with the extent of the harm, including voluntary death that may be inflicted on the assailant in the exercise of the right of body and property, respectively. So section 98 makes the right of a private defense available against the person who by reason of infancy and insanity, intoxications, or misconceptions are legally incompetent to commit an offense. So as per section 90, the person who cannot commit an offense, but this right is available to you even against those persons. And section 106 allow a person to take the risk of harming innocent person in order to the exercise of a right of a private defense body, save himself from mortal injury. So this is related to the part of a section 96. We have already stated that nothing is an offense. Now we will go through the section 97. So section 97 is related to the right of a private defense of the body and the property. So it clearly mentions section 97 that every person has a right subject to restrictions contained in section 99. So whatever the restriction that is mentioned in section 99, first his own body and the body of any other person. So as per section 97, this right is available to his own body for the himself and the body of any other person. So as in England, it is related to the person who known to him. Here the word used in section 97 is any other person against any offense affecting the human body. So section 97 has two parts. Firstly related to the body and secondly is related to the, you can say, property. So it further stated in second part that secondly, whether immovable or immovable. So person has a right regarding the property of movable and immovable of himself or any other person. So again, the word used is any other person. So this right is available to a person not to the defend of his property, but the property of other person also. Against any act which is an offense falling under the definition of theft, robbery, mischief, criminal trespass, which is an attempt to commit theft, robbery, mischief, or criminal trespass. So this right against the property is not only available for the offense, but also an attempt part also. So जो राइट ऑफ प्राइवेट डिफेंस है, ये एक डिफेंसिव राइट है। ये आपको ये नहीं लॉ करता भी आप उसकी पुनिशमेंट उसको दो जिसने वो किया है। पुनिशमेंट इज गिवन बाय द स्टेट, not by that person. You can use only your right just to protect you and yourself. So it is a defensive right which justify to repel the unlawful aggressions. So it is not a basical, a preventive. So it is a basical in preventive in nature, but not punitive in nature. आपने उसको पुनिश नहीं करना, आपने तो अपने आप को प्रिवेंट करना है। However, जैसे जो मॉन्क्स हैं, बुद्धिस्ट हैं, जैनिज्म के भिक्षुस हैं, वो उतनी ही फोर्स यूज करते हैं जितना वो आप डिफेंड हो सके। आप वो उससे ज्यादा फोर्स नहीं यूज करते बिकॉज दे फॉलो द प्रिंसिपल ऑफ अहिंसा। सो ऑन द बेस ऑफ दैट वी कैन कंसिडर दैट थ्योरी। तो इसके अंदर भी अगर आप फोर्स ज्यादा यूज कर जाओगे तो दैट विल बिकम्स एन ऑफेंस। सो राइट ऑफ डिफेंड does not include a right to launch an offense, or you use the force and that force should not be disproportionate to your injuries. तो आपने उससे ज्यादा फोर्स यूज नहीं करना। So one of the case is Ram Ratan Singh versus State of Bihar. It is citation is AIR 9065, page Supreme Court 926. In this case, the complainant who has a number of cattle and his cattle trespassed into the field of another person and start grazing. And the accused party, in whose farm the cattle entered, seized the cattle and was taking them to the pond. When the complainant party came to know this fact, they came to the spot along with the number of persons, along with the weapons, and to rescue that cattle because they were captured by the person in whose farm they were grazing. The Supreme Court held that since the complainant party had come armed with sharp-edged weapons and lathis to rescue the cattle from the accused party, the accused party had apprehended that they were not peacefully inclined and would use the force against them in order to rescue the cattle, and that force is likely to be used could cause grievous harms. In view of this, the court held that the accused party had committed no offense in causing injuries to the person in the complainant party and even causing the death of one of them. क्योंकि जो कंप्लेनेंट्स का फॉर्म था उसके अंदर कैटल्स गई थी और ये जो क्यूज पार्टी हु आर द ओनर्स ऑफ द कैटल वेंट टू द फील्ड ऑफ द दैट पर्सन. So that's why under these conditions it is considered to be offense. So one of the other important case, that is Jaidev versus State of Punjab. इस केस के अंदर a piece of the land was brought by the accused party in the neighbor village, and since they were outsider of the village, so when the accused who were armed with the plowing the field in the disrupted land, the village, तो जब ये वहां पे गए तो जो विलेजर थे तो उन्होंने इसको डिस्टर्ब किया. So this party has given a firing in which Amin Lal has been dead. तो जब अमीन लाल की डेथ होगी, the other persons run away from the spot. So when they run away, so private defense you can use only up to that extent. जब वो अग्रेसर थे, जब वो भागी गए, and this accused has killed two other person of the villagers when they flee, जब वो दौड़ रहे थे. So the Supreme Court said the right of private defense is only available at the time of killing Amin Lal, but it is not available to kill the fleeing villagers. जो विलेजर्स भाग रहे थे, विलेजर्स, उनको मारने का आपके पास कोई डिफेंस नहीं था. So the accused was convicted for the murder. In other important case, that is Nabiawai versus State of Madhya Pradesh. In this case, one, the accused, along with her mother and sister. So all the three ladies, Nabiabai, accused, and her mother and sister were weeding their crops when the deceased passed through the neighbor fields. The deceased then came into the field and attacked all the three with a knife. तो उसने जो नाइफ से तीनों के ऊपर अटैक कर दिया. And one of the accused get hold of the knife by the deceased and inflicting injuries resulting with death. तो उसका जो नाइफ था उसी से ही लेके उसको मार दिया. So the Supreme Court observed that accused has neither motive, neither any intentions to kill the deceased, and they had did just act to save themselves, जो कि उनके ऊपर नाइफ से इंजरीज कर रहा था. So all the three accused were acquitted. So one other important case, that is Rajesh Kumar versus Dharamveer. It is AIR 97, Supreme Court, page 3769. In this case, there was a dispute of a shop, which there was a common wall, and the accused जो था, he murdered a person after, when the matter was just, you can say, a hot exchange, or the words when becomes end. So in this case, one of the party, the accused party, had a dispute, and accused part starting demolishing the wall. Hearing this sound, the party of the deceased came out on the lane and shouted at the shop. In the rift between two, one was killed. The accused took the plea of a private defense, stating that deceased had tried to break open their outer door. In the defense of their property, they had to kill the deceased. So this was the defense taken by the accused. But the incident took place outside on the lane and not inside the house. The Supreme Court held that even assuming that the version put by the defense was correct, only as long as the deceased party continue in the commission of offense of breaking, and accused had the right of a private defense. But it ended the moment end हो गई, the commission of the mischief was done. They attacked the deceased in the lane after the damage was over. The Supreme Court held that the right of defense can exercise only repel unlawful aggressions, not to retaliate. The right under Section 96 was one of the defense and not a retaliations. So that's why this was rejected by the Supreme Court in this case. So right of जो private defense होता है, that is not available to the aggressor. Aggressor जो है उसको ये right of जो private defense is not available. Even it is also not available against the lawful acts. If a person has do a lawful act, suppose if a person has taking the possession by the order of a court, he is doing a lawful act. And for doing that lawful act, the if other person has used a force to stop it, then the right of private defense is not available. So one of the important case that is Kanwar Singh versus Delhi administrations. AIR 1965, Supreme Court, page 871. In this case, the raiding party, who as a possessing authority under a section of a Delhi municipal corporations, seized the stray cattle belonging to the accused. The accused registered that the seizure of the cattle and inflicted the injury to the raiding party. Since the raiding party was coming out of is carrying a lawful act, they are discharging their duty, which is given to them as per the law. So they are justifiable to seize that cattle. So, so in that case, whatever the injury caused by the accused, and this right is not available to the Kanwar Singh. So he was convicted. So similarly, in case, so the question is further related to the जो right of private defense है, क्या this one is, we can say section 90 is specially mentioned. It is also a private defense even against those persons which who cannot commit an offense due to the unsound minds, due to the you can say intoxications, and due to the insanity or due to a child. So section 98 is specifically mentioned that when act which is otherwise a certain offense is not that offense by reason of the youth, the want of maturity or understanding or unsoundness of mind or intoxications or by misconception of a fact. But every person has the same right of a private defense as per this section 98 against that act which he would have if that act was that offense. So this right of a private defense even is available to those persons to whom the law has given a immunity to commit an offense. So we consider that act of the lunatic, intoxicate person or act done under the mistakes are no offense. So the private defense is available even against these persons. So the facts, if where a person is a youth or intoxicated person, so the other person does not lose his right of a private defense because the other party is incompetent to commit an offense. So in case you can say that a person or a property of other person and a member of a public entitled to excuse the right of private defense against the person to whom even the protection was given by this. So one case, Munshi Ram versus Delhi administrations. It's AIR 1968, Supreme Court, that is page 702. In this case, Supreme Court held, although the accused has not taken a plea of defense in the statement necessity, basis of the plea has made in the cross examinations of the prosecution witness. So it has been said that even the accused has not plead a defense, but even the court can consider that plea. So normally the burden जो होता है वो accused के ऊपर होता है to prove. Under section 105 के अंदर the person who alleges will prove any general exceptions. But regarding the private defense, as stated in the Munshiram Delhi administrations, अगर आपने डिफेंस नहीं लिया, but on the facts of the cross examination of the witness, it is came to the court that it is a case of a self defense. So then court can give a benefit of doubt on the basis of that. Even the law go to this extent. Even if you have taken a defense of a alibi, मैं तो वहां पे नहीं था, and your defense is failed, but on the basis of the prosecution case and the cross examination of a witness, it comes the case of a self defense. So even then the court can give a right of this. So this is the case where a person has this given a right to a person even who has not taken a defense. So regarding the one case is regarding that available against a drunkard persons, Min Kirki versus Emperor, AIR 1995. It's a Rangoon High Court case where it is mentioned that even the drunkard man himself is entitled a protection of law in this, and a individual, as per this Rangoon High Court has said, that it is a protection of legal abnormality. Even a drunken man breaks the law, the attacks either the person or a property, the other man has a right of a private defense against drunkard persons. So we will discuss this defense, private defense, in two or three parts. So today is our one part of a lectures, and the remaining lectures I will give you a tomorrow. So any question you can put me on the regarding up to which we have did, and tomorrow at the same time at around 7:15 we will do further. Okay, thank you.